Hello, my name is Isabella Jang, and today I will be presenting my current case brief presentation with the R.V. Anine 2016 ONCJ 1115. Philip Anine is charged on the second day of October 2014 at 6:10 p.m. eastbound at 130 Howard Park Avenue in the city of Toronto with the offense of careless driving, which is contradictory to the Section 130 of the Highway Traffic Act RSO 1990 CH8. The Section 130 of the Highway Traffic Act, SUPRA, stated that every person is guilty of the offense of driving carelessly who drives a vehicle or streetcar on the highway without due care and attention or without reasonable consideration for other persons using the highway and upon conditions is liable to a fine of not less than $400 and not more than $2,000 or to imprisonment for a term of not more than 6 months or to both. Suspension of license might be applied for a period of no more than 2 years. Therefore, in terms of this case, the issue that needed to be solved is whether or not the defendant's conduct and manner of driving was of such a nature that constitutes careless driving. After deep investigation, the court found that the prosecution has not met its onus of proving beyond a reasonable doubt that the defendant was driving without due care and attention or without reasonable consideration for other persons using the highway on October 2, 2014. The court finds the defendant not guilty of contravening Section 130 of the Highway Traffic Act (SUPRA). The defendant testified that he stopped for the flashing lights at the crosswalk. He stated that Ms. McCartney was crossing the sidewalk on Howard Park Avenue at Sunnyside Avenue with her daughter and an unleashed dog. The defendant then honked at Ms. McCartney in an attempt to get her attention, although Ms. McCartney did not even approach the defendant's vehicle. By contrast, she proceeded to yell at the defendant, making reference to his origins while scolding him for honking in her neighborhood. The defendant proceeded only after Ms. McCartney. The defendant stated that Ms. McCartney was crossing the road from south to north, while this statement differs from the complaint's evidence. Ms. McCartney provided that she was no more than 1.5 meters or one car lane into the roadway when she heard the defendant honking at her and did not understand why he was doing that. For that reason, she went up to the defendant's driver's side window and leaned into it. The defendant proceeded to move forward, accelerating his vehicle in such a manner and speed as to have bumped her stomach and hit her dog. The only reason he did not hit her child was because the child was behind her, which would have placed her daughter, if not over, then near the lane of traffic for oncoming traffic. Ms. McCartney stated that there was no need for her to attend a doctor's office, in spite of being pregnant to being hit by the defendant in her stomach. She was neither hurt nor injured, but stunned. She then further reiterated that she was pushed back out of the way by the defendant's vehicle as he sped off. Her dog was also struck by the front left tire of the defendant's vehicle. However, she did not have her dog looked at until the next day. She did not provide the court with any vet bills, but did indicate in her evidence that the dog was not hurt. In fact, the hit was actually an impact. The complainant states that she leaned into his vehicle, and when he took off, she was pushed back. Yet she initially stated that her pregnant stomach was hit by the defendant's vehicle, but only her dog, at the end of the day, was impacted by the defendant's vehicle's front left tire when he took off. Yet the dog was on a leash beside her, and if the court accepts this, then how could the dog have been hit by the defendant's vehicle's left tire? For this to have occurred, the dog would have had to have been in front of the vehicle, or at least in front of the tire, which the court finds that the dog could not have been. Later on in the investigation, the court found that the defendant did stop on the road, not far from this crosswalk. After applying the test set out in RVMD Supra, the evidence showed that the defendant is believable and has credibility. The court further finds that there was no accident, and that the defendant was in fact driving with due care and attention when he stopped at the crosswalk. The court finds that the complainant did not lean into the defendant's vehicle and that he did not speed off in a manner that constituted careless driving. If the defendant hit the complainant's stomach and her dog in such a manner, why did they not go to doctors immediately? But instead, she did not seek any medical care, nor did she seek any medical care for her dog. In conclusion, the complainant's evidence does not merit a finding that the defendant drove on the highway in a manner that was without due care and attention, or without reasonable consideration for other persons using the highway. It is common cause that the defendant stop for the complainant. This court finds that the prosecution has not proven the charge of careless driving beyond a reasonable doubt, as the second element of the offense required for a conviction has not been established. Cases like this not only happen in Toronto, but all around the world. Especially in China, hundreds of similar careless driving cases happen per day. People should be aware of their surroundings both when they're driving and when they are the pedestrians. In conclusion, I will pose a survey question. Can this type of case be analyzed as one of the cases of fraud, which the complaint tries to fake an accident to claim for compensation? Thank you for listening and have a good day.